At exactly 10:03 this morning, a decision consisting of just a few words brought every remaining legal maneuver to an abrupt end. What makes this moment extraordinary is not only the decision itself, but the timing. It came precisely 72 hours after a private legal offer quietly reached federal prosecutors. From that moment forward, there was no longer a pause button, no procedural escape hatch, and no remaining room to delay what comes next. This is not speculation. This is not anonymous sourcing. What you are about to hear is based entirely on court filings, sworn declarations, and official Supreme Court orders. These are public records. They can be verified by anyone willing to read them, and once you understand the sequence of events, it becomes clear why this case has now entered a phase that cannot be reversed. To understand why the Supreme Court acted with such speed and finality, we have to walk through the exact 72-hour timeline. Because this did not happen by accident. Hour zero begins on Monday afternoon. At approximately 2 o'clock Eastern Time, legal counsel for Melania Trump submitted what is known in federal practice as an offer of proof to the Office of the Special Prosecutor. In simple terms, an offer of proof is a preview. It tells prosecutors exactly what a witness knows, what evidence they can provide, and what testimony they are prepared to give under oath. In exchange, prosecutors may consider immunity or limited protection. Offers of proof are not unusual in federal cases. What makes this one extraordinary is the identity of the witness and the scope of what was offered. 24 hours later, on Tuesday afternoon, the defense team responded with remarkable speed. An emergency appeal was filed directly to the Supreme Court of the United States. The request was simple on its face. Block the testimony before a grand jury could hear it. The argument relied on marital privilege and constitutional privacy protections. What is notable here is not just the argument, but the timing. Emergency appeals of this nature often take weeks to prepare. This one was assembled in a single day. That alone suggests the defense knew exactly what was coming. At hour 48, Wednesday morning, the Supreme Court docketed the appeal. A case number was assigned, but something critical did not happen. The court did not issue a stay. A stay would have frozen the process while the justices considered the matter. Without a stay, the legal machinery continued moving forward. In Supreme Court practice, silence at this stage is rarely neutral. It often signals skepticism. Then came hour 72. Thursday morning, at 10:03. The court issued its decision. One sentence. Application denied. No dissents. No concurring opinions. No explanation. When the Supreme Court writes nothing, it is often saying everything. This was not a close call. And from this moment forward, the timeline of this case accelerates rather than slows. To understand why prosecutors moved so decisively after receiving the offer of proof, it is essential to understand what was actually placed on the table. An offer of proof is not a vague promise of cooperation. It is a structured legal document that outlines specific evidence, specific testimony, and the factual foundation a witness is prepared to provide under oath. In federal practice, prosecutors do not even consider immunity unless the offer is concrete, verifiable, and capable of materially advancing the case. According to the filings, the evidence described in this offer falls first and foremost into a category that federal prosecutors take extremely seriously: financial documentation. These are not secondary records or third-party summaries. They are primary documents, signed and certified under penalty of perjury. For 6 consecutive years, from 2014 through 2020, joint tax returns were filed bearing the signatures of both spouses. Under federal law, a joint tax return is not symbolic. By signing, each spouse affirms that the financial information reported is accurate to the best of their knowledge. Asset valuations are not minor details in these filings. They determine taxable income, deductions, depreciation, and liability. When the same assets are presented at one value to taxing authorities, and at a different value to banks for loan purposes, that discrepancy becomes legally significant. The offer of proof states that the witness was present during meetings with accountants where asset values were discussed in detail. These were not casual conversations. They involved how properties would be valued for tax reporting, how income streams would be characterized, and how those figures would be presented externally. Emails documenting these discussions are already in the possession of federal prosecutors. In several instances, the witness is described as asking questions about why reported values differed depending on the audience. That matters because knowledge is a core element of intent. In white-collar prosecutions, prosecutors are not required to prove that a defendant personally prepared financial documents. They must prove awareness and participation in a scheme. Attendance at valuation meetings, direct inquiries about reporting differences, and signatures on official filings all contribute to that picture. Each individual piece of evidence may appear technical on its own. Together, they begin to establish a pattern. This is why joint financial documents are so powerful in federal court. They tie multiple individuals to the same representations. They eliminate plausible deniability. And when those documents are paired with testimony explaining how and why valuations were discussed internally, the evidentiary weight increases dramatically. From the prosecutor's perspective, this category of evidence does more than support existing charges. It provides context, continuity, and motive. It shows how financial decisions were made over time, not in isolation. And it explains why this offer of proof was treated as a turning point rather than a routine submission. Financial documents establish a foundation. But federal prosecutors rarely rely on paperwork alone. What transforms a technical financial case into a compelling prosecution is communication. Words, messages, conversations. The offer of proof makes clear that this second category of evidence is where the case begins to tighten significantly. According to the submission, prosecutors were presented with a body of communications that connect internal financial discussions directly to external representations. These communications include text messages between the witness and the accused, discussing property values in advance of meetings with lenders. They include emails exchanged with accountants questioning why certain valuations appeared higher in loan applications than in tax filings. And most significantly, they include recorded phone conversations where asset values were discussed in the context of securing financing. In federal cases, communications serve two critical purposes. First, they demonstrate knowledge. Second, they establish intent. A financial discrepancy can sometimes be explained away as error or misunderstanding. A written or recorded discussion acknowledging those discrepancies removes that defense. When individuals discuss what numbers will be presented, to whom, and for what purpose, the legal analysis changes. Recorded conversations are particularly powerful. If a recording is made in compliance with consent laws, it is admissible evidence. Before such material is included in an offer of proof, prosecutors verify its authenticity, chain of custody, and legal admissibility. This is not speculative evidence. It is evidence that has already been vetted. In white-collar prosecutions, recordings often function as the moment when defenses collapse, because they capture intent in the defendant's own words. But communications alone are still not enough. Federal prosecutors require corroboration. This is where the third category of evidence becomes decisive. The witness is not offering testimony in isolation. The offer of proof states that her testimony aligns with what accountants have already told the grand jury under oath. It aligns with what bankers testified regarding loan applications. It aligns with what property appraisers described when explaining how valuations were influenced or pressured. Corroboration is the backbone of federal prosecutions. One witness can be attacked as biased. Two witnesses raise concern. Three witnesses supported by documents establish a pattern. When testimony, emails, recordings, and third-party witnesses all describe the same meetings, the same discussions, and the same outcomes, prosecutors begin to speak in terms of systems rather than incidents. This is why this category of evidence matters so deeply. It does not merely add detail. It closes gaps. It connects documents to decisions, and decisions to deliberate actions. From a legal standpoint, it transforms allegations into a narrative that can be proven beyond a reasonable doubt. At this stage, the evidence is no longer about whether questionable valuations existed. It is about whether those valuations were knowingly coordinated. And once communications and corroboration align, that question becomes far more difficult for any defense to answer. At the center of this case lies a legal decision that fundamentally reshapes its trajectory. It is not a procedural technicality. It is not a narrow evidentiary ruling. It is the voluntary waiver of spousal privilege. And in federal law, that choice carries consequences that cannot be undone. To understand why the Supreme Court reacted the way it did, it is important to clarify what spousal privilege actually means. In federal evidence law, there are two distinct protections, often confused as one. The first is the marital communications privilege, which protects private communications made during a marriage. The second is the spousal testimonial privilege, which allows a spouse to decline to testify against the other in a criminal case. These privileges exist to protect marital harmony, but they are not absolute. For more than 4 decades, the controlling law on this issue has been settled. In 1980, the Supreme Court decided Trammell v. United States. That ruling changed the landscape entirely. Prior to Trammell, a defendant could block a spouse from testifying by invoking privilege. Trammell reversed that rule. The court held that the privilege belongs to the witness, not the accused. In other words, if a spouse chooses to testify, the defendant has no legal power to stop it. That principle is critical here. According to the offer of proof, the witness explicitly waived spousal privilege for all matters covered by her cooperation. This was not the result of a subpoena. It was not compelled by threat. It was an affirmative, voluntary decision documented in a formal legal agreement. Once that waiver occurred, the legal barrier the defense attempted to rely on simply no longer existed. This is why claims of constitutional violation fell flat. The Fifth Amendment does not prohibit voluntary testimony. Privacy protections do not apply when the holder of the privilege chooses to relinquish it. Courts evaluate voluntariness using a clear standard. Did the witness initiate contact? Were threats made? Was prosecution used as leverage? In this case, sworn declarations state that the witness approached prosecutors through counsel, proposed cooperation, and negotiated terms. That sequence matters. Cases involving spousal cooperation are not unheard of in federal court. They have appeared in organized crime prosecutions and in corporate fraud cases, where financial exposure is shared. What makes this situation unprecedented is not the legal mechanism, but the level of power involved. A spouse of a former holder of the highest office in the country stepping forward with documents, communications, and direct testimony is rare. But rarity does not change the law. Once the privilege was waived, the defense had no remaining doctrinal foothold. Trammell has never been overturned. Every federal circuit follows it. Asking the Supreme Court to block testimony under these circumstances required the court to ignore its own precedent. That was never a realistic outcome, and that is why, when the appeal reached the court, the response was not measured hesitation. It was swift rejection. When the Supreme Court denies an emergency appeal in a single sentence, it is not acting casually. It is signaling that the legal arguments presented failed at the most basic level required for intervention. To understand why this rejection was so swift and so absolute, we need to look at the standards the court applies in emergency applications. An emergency appeal to the Supreme Court must satisfy 2 core requirements. First, the applicant must demonstrate irreparable harm. Second, they must show a meaningful likelihood of success on the merits. Failing either prong is fatal. In this case, The defense failed both. The first argument advanced by the defense was that allowing spousal testimony would violate constitutional privacy protections. That argument collapses immediately under existing law, as established in Trammell v. United States. The spousal testimonial privilege belongs to the witness, not the accused. Once the witness voluntarily waives that privilege, there is no constitutional injury in allowing testimony to proceed. Courts have reaffirmed this principle for more than 40 years. The Supreme Court was not being asked to clarify unsettled law. It was being asked to ignore settled precedent. The second argument alleged coercion. The defense claimed that the cooperation was the result of pressure, threats, or prosecutorial leverage. But this claim was directly contradicted by sworn affidavits. Those filings state that the witness initiated contact with prosecutors through counsel, proposed cooperation voluntarily, and negotiated terms without any subpoena or threat of prosecution. Federal courts apply a clear test for voluntariness. When a witness approaches prosecutors on their own initiative, cooperation is considered voluntary as a matter of law. That alone undermined the second argument entirely. The third argument warned of a dangerous precedent. According to the defense, permitting this testimony would erode marital privacy protections in future cases. But this argument misunderstands how precedent works. The precedent already exists. Spouses testify voluntarily in federal court every year. Trammell resolved this question in 1980. What the defense was effectively asking for was a special exemption based on the identity of the accused. The Supreme Court does not create constitutional carve-outs for status or power. These failures explain the form of the court's response. When justices issue written opinions, even short ones, it signals that the legal question required explanation. When they issue a one-sentence denial with no dissents, it reflects a conclusion that the appeal was not worthy of extended consideration. In legal terms, the arguments were frivolous. There was also no showing of irreparable harm. The mere fact that testimony may proceed is not harm. It is the normal operation of the justice system. To succeed, the defense would have needed to persuade the court to suspend the law itself. That was never going to happen. This is why the court did not pause. It did not hedge. It closed the door completely. And with that door closed, the case moves forward without delay, with the Supreme Court's denial now final. The procedural posture of this case changes immediately. There are no remaining emergency appeals. There are no unresolved privilege claims. The phase defined by delay has ended, and the evidentiary phase now moves forward without obstruction. The next step occurs inside the grand jury room. In this district, grand juries typically convene multiple times each week. With no stay in place and no legal barriers remaining, prosecutors are free to present testimony as soon as they are ready. Based on the level of preparation reflected in the filings, testimony could occur within days rather than weeks. Once testimony is given under oath, it becomes part of the permanent investigative record. From there, prosecutors face a strategic decision. They may choose to use the testimony to reinforce existing charges, strengthening proof of knowledge, intent, and coordination. Financial cases often rise or fall on intent, and corroborated testimony can dramatically increase the strength of an already filed indictment. The alternative is more consequential. Prosecutors may seek a superseding indictment, adding new charges based on newly developed evidence. If testimony establishes coordinated misrepresentations to lenders, particularly when supported by recorded communications, conspiracy charges become a realistic possibility. Conspiracy is a separate offense under federal law. It does not require success, only agreement and an overt act in furtherance of that agreement. Even a single coordinated conversation followed by a loan application can satisfy that standard. If additional charges are brought, legal exposure changes significantly, affecting sentencing ranges, trial strategy, and leverage. At this point, the trial schedule is no longer theoretical. With procedural avenues exhausted, courts are unlikely to move dates absent extraordinary circumstances. The system is now operating on a fixed timeline. Now, I want to step back briefly and offer a personal perspective, not as speculation, but as professional observation. In decades of watching federal cases unfold, moments like this are rare, not because the law is unclear, but because it is applied decisively. Powerful defendants often rely on delay, procedural complexity, and privilege claims to stretch cases indefinitely. What stands out here is not that the law changed, but that it did not bend. The Supreme Court applied settled precedent without hesitation, and that alone reshaped the case. That said, it is important to be precise about what this moment does and does not mean. This analysis does not assert guilt. It does not predict a verdict. Under the law, every defendant remains presumed innocent unless and until proven guilty beyond a reasonable doubt in a court of law. What this moment represents is not an outcome, but a turning point. Evidence will now be evaluated on its merits, without delay tactics standing in the way. This discussion is intended for informational and educational purposes only. It reflects analysis of publicly available court records, legal standards, and procedural developments. It is not legal advice, and it should not be interpreted as a substitute for professional counsel or judicial determination. The final resolution of this case will depend on evidence presented in court, rulings by judges, and findings by a jury. What happens next will be driven by testimony, documents, and corroboration, not rhetoric or speculation. And that is precisely how the justice system is designed to function when it is allowed to operate without interference.